Hi, Benjamin Jaffe with SQ Law. We've gotten quite a few hits recently on a blog that we posted regarding domestic violence victims or someone that's accusing someone of domestic violence and them not showing up for court and what could happen. I want to talk about that a little bit because I do think there's some confusion as to what can and can't go on in those situations. But I'll talk about it in a way that applies to just, I guess, witnesses in general at first. So, witnesses on a criminal case, you have a right as defense to hear what they're going to say. And in Indiana, you actually have a right to take their deposition and or tape statement. And so oftentimes we will want to take a tape statement or deposition of either an alleged victim or a witness of some sort. Um, if that person does not show up for a tape statement, that could be problematic. We are required to subpoena witnesses to tape statements and or depositions. So they are sent legal notice that they're required to be, where they're being requested. So if they don't show up, we will generally be required to try again and double check to make sure, I guess, that they're being put on notice and it's going to the right address and those sorts of things. But we're required to at least give it a couple of attempts. If someone does not show up after a couple of attempts to take their statement, oftentimes we can file something with the court that excludes them as a witness. Now, it's not cut and dry. A lot of people think you get two shots at it and then it's over with. It all depends. If there's some showing that that person did not receive proper notice, or there's some legitimate excuse as to why they weren't there, oftentimes courts will allow another opportunity to take the statements. I will say that courts don't have infinite patience with that sort of thing. The bottom line is we have a right to take statements from witnesses and or victims. And if there's a lack of cooperation in that regard, ultimately courts will exclude the witnesses if necessary. Technically, the courts can require them to be there and find them in contempt of court or do a body attachment of some sort. It's pretty uncommon, but it does happen. We've seen it most in cases where there are actual witnesses that the case needs, the state needs for a serious case. For example, let's just say a murder and there's a very important witness who doesn't want to participate. I have seen situations where the state asks for body attachments and they're granted because people don't show up. So if someone is identified as a witness in a case, they are required to cooperate in those regards, and there can be consequences. And from the defense's perspective, one of those consequences can be that they are excluded as a witness. Now, getting more specific about a victim of a crime. So what we commonly see is domestic violence cases where someone's made an accusation, and oftentimes we'll have people say, hey, this isn't true, they're accusing me of this, and I don't think they are going to want to show up because they're going to be put under oath and they don't want to lie or something along those lines. But we oftentimes will get situations like that where someone is unlikely to show up or we're receiving some information that they may not. So we are still required to send out notices of depositions. If I talk to that witness on the phone or something like that, or they communicate with me, I am required to tell them that they have a duty to come in on this. If they choose not to, I guess that's up to them, and that's, they have to deal with that. But I also always encourage them, if you want this case prosecuted, you should come to this because this is your opportunity to be heard. And if you don't come, you could be excluded and you wouldn't have the right to be a part of the case anymore. So we do run into circumstances like that, but oftentimes, especially in domestic violence cases, it's not uncommon for people not to show up or victims not to show up, and that they don't, for whatever reason, they don't want to pursue what the state has filed. And so in circumstances like that, there's no hard and fast rule, but oftentimes those witnesses will be excluded, and oftentimes that will lead to a dismissal of the case. Now, with that being said, the times it doesn't lead to a dismissal is there are additional pieces of evidence, or there are additional witnesses and or ways for the state to prove even without that witness. So again, there's not a hard and fast rule that if they're excluded, the case goes away. Commonly it does because the case relies solely on that particular witness, but don't be surprised if it doesn't go away, and your attorney frankly should be explaining to you what all the possibilities are. And that's something we always do at SQ Law, is to make sure you understand the possibilities and what might happen depending on the circumstances.